Welcome to GovCon Intelligence. The burdens on the small business defense industrial base have been in the news lately, especially with the Department of War's recent pause on CMMC Phase 2. But there's still more burdens to come. Today we're going to be talking about the upcoming changes to disclosure on foreign ownership, control, and influence, or FOCI. There are changes to the applicability of the FOCI rules to small business contracts, even as low as $5 million. So my guest today to get into this FOCI issue is Erin Estevez. Erin is a government contracts attorney who's been practicing for 16 years, particularly with small businesses and the defense industrial base. Erin, welcome to GovCon Intelligence.
Thanks for having me, Sam. I appreciate it.
Tell us first, under the current rules, what happens now? Is this just a Department of War issue, or is it broader than that? How is foreign ownership, control, and influence tracked among suppliers and companies supplying the federal government?
Sure. So focusing specifically on the Department of War, there is really no comprehensive way that they track foreign investment in their contractors. The only sort of comprehensive regime that exists right now for the defense industrial base is in the classified space. So any contractor that has a classified requirement on a DoD contract has to go through a very similar process to what we're going to talk about today. They fill out a form called the SF-328, which is a certificate pertaining to foreign interests. And as we'll discuss in detail, it tracks information about ownership and other sort of foreign touch points. And then the contractor goes through a review process with the DCSA, which is the Defense Counterintelligence and Security Agency. Depending on the outcome of that diligence, DCSA might require the contractor to put some mitigation instruments in place to deal with any potential threat to national security or classified information that the government judges could come from that FOCI that's identified for a particular contractor. The contractor is then required for implementing the FOCI mitigation, and the contract performance can move forward. So that's a very familiar process in the classified space. Otherwise, DoD gets some insight into foreign ownership through things like the CFIUS process, right? If there's an investment that goes through CFIUS, DoD is part of that review. Oftentimes there's parallel DCSA and CFIUS reviews if it's a cleared contractor. There are certain programs where foreign involvement is also part of the initial assessment. So SBIR, for example, right? There's limitations on other than U.S. ownership and control.
And those were just made stricter in the recent SBIR reauthorization.
Yep. And now we have the foreign risk investment review, the foreign risk reviews for SBIR contracts as well. And then certain contracts themselves will have provisions that either in the solicitation materials put some limits on foreign involvement, either in the supply chain or the ownership structure of the offerer, or have an issued contract that says foreign access to technology, for example. If there's going to be a transfer of technology developed in the contractor has to notify the government and go through a review process. And so, again, these are kind of siloed operations that come up in very distinct contexts. There's not really an overarching regime for tracking and monitoring and mitigating that foreign ownership or control in defense contractors. And so this is really an attempt to come up with a regime that would cover that in a more holistic way.
So it's been scattershot up till now. You've had classified contracts completely covered, but then otherwise contract by contract or in particular programs. What is the proposal to change this regime?
So this regime would now expand essentially what DCSA and DoD does for classified contractors to all DoD contractors with contracts over $5 million. And so it's a really significant expansion of the current regime, and it's not something that contractors outside of the classified space have had to really manage in the past. And so, I think a lot of the concern that we see coming out of industry is how well does this system that's currently in place for classified contracts really translate to the broader contracting base for DoD. How is DoD going to manage the influx of cases that they now have to manage? How is it going to impact the acquisition timeline, and lots of other concerns about sort of the implementation, I think, in particular.
Oh, that's interesting. So it's not just the impact on the companies in, now I'm over $5 million, I have to fill out this form, I could be at risk of being found non-responsible or having some sort of mitigation measure, but also just generally timeline-wise, it could slow down procurement. So how long does that usually take in the classified area?
Yeah, so it routinely takes like 6 to 12 months to go through the disclosure, mitigation requirement, sort of the negotiation of what those requirements will be, and then there's a period of time contractors have to implement the mitigation once that contract performance begins. And it really depends on how complex the ownership structure is, what the foreign touch points are, what kind of mitigation could be required. And certainly some of that is driven also by DCSA's workload, how quickly they can be responsive. And they've actually worked very hard the last few years to keep those timelines on the lower end of the spectrum to the extent that they're able to. So with that as a backdrop, given how significantly the caseload is going to increase, the current rule proposes that DCSA will review new FOCI submissions within 25 working days of their submission, and then post contract award, the contractors have that 90-day period to implement the requirements. I think there is some healthy skepticism about how quickly DCSA is really going to be able to work through those, which is understandable given the jump in total cases that will be coming across their desk.
So let me just be more specific about what we're talking about. Proposed rule that was published by Department of Defense under the DFARS, Defense Acquisition Regulation System, May 7th, 2026. Comments were filed already. Comments were due July 6, 2026, and this would affect solicitation provisions in Part 40 or 240 of the DFARS. Under the rule, the disclosure would require filling out this form that you mentioned, the standard form 328, and the form is straightforward, I suppose. It has 9 questions, so it's not a long form. But in looking at it, the fact that this rule applies to foreign ownership, control, or influence, I think is a bit misleading, because the form has a lot more than that. And one of the questions is question number 5, does your organization have any contracts, agreements, understandings, grants, side letters, or arrangements with a foreign person? It also gets into revenue, agreements, debt. How broadly is this going to apply, particularly to small businesses? How likely is it that they're going to have to disclose something if they read through these questions and realize, oh, maybe I do have a foreign contract, or I do get revenue from foreign sources?
So very broadly, was sort of the short answer to the question. The form itself is sort of deceptively simple on its face. As you start reading the questions, as you noted, this is really much more expansive than just ownership. And for a long time in the classified space, there was a real emphasis on ownership being the primary concern coming out of these FOCI reviews. In the last number of years, DCSA has really moved to focus more and more on the other vectors of control and influence, right? The C and the I in FOCI. And the nature of the questions really recognizes that a company can be influenced certainly by ownership in the traditional sense. But if they have a large debt instrument with a foreign bank, if they have a significant customer relationship overseas, if they have a large constellation of their contracts with foreign vendors, for example, that could significantly influence their performance of classified contracts and safeguarding of classified information. And so as you read through the form, I think question 5 does stand out to lots of folks because it is so expansive. Now, lots of the other pages of the form are instructions for the questions, and they have worked hard to give a lot more context to what they're really asking for. For question 5, it does require disclosure of supplier agreements, customer relationships overseas. The instructions even reference employee under visa sponsorships. So even in that context, you're talking about an agreement with a foreign person. And so reading the instructions and really understanding what the context for this exercise is, I think goes a long way to helping contractors understand how expansive it is and why it is as expansive as it is. I will caveat that by saying, just because you have a disclosure on this form, right? Let's say you have a vendor in France. Let's say you have a constellation of customers in, South Africa or something along those lines. That doesn't necessarily mean you are going to be prohibited from performing classified work, or under this new rule, a contract over $5 million, or even that to do that, you would need to be under a mitigation instrument. What DCSA is trying to do is get an overall picture of the various vectors of ownership, control, or influence by foreign individuals or companies over this particular contractor. And given that picture as a whole, what does DCSA feel like the threat is, and how can that be mitigated if there is one? And so there will be circumstances where we have a yes response. There's the second page of the form provides a space for remarks where you explain yes responses, and you can attach additional pages. And then we have, like I said, circumstances where a yes response doesn't result in any mitigation, as long as the information is provided. And so it's really important that companies, as they're preparing for this process, read the form carefully, kind of understand how expansive it is, and start collecting that information sooner rather than later, because it can take quite a long time to really gather if this is not an exercise a contractor has done before.
What about commercial contractors? Are they going to be affected by this?
Yeah, so the rule right now exempts commercial acquisitions, but it leaves room for a senior DoD official to decide that a particular commercial acquisition is covered if there are risks to national security based on sensitive data or processes or systems. Now, most of those terms that I just used are not defined in the rule. And so they have not named the DoD official who will be in charge, or sort of the level of seniority that will be required. They have not disclosed the criteria that will be used to decide if a commercial acquisition would be covered, or defined sort of that sensitive data process or system aspect of the exemption. So it's very hard to tell at the proposed rule stage really how narrow or broad that exemption will be. It's possible that very few commercial acquisitions are actually pulled into the scope, or that many could be. And that's one of the concerns we've heard from industry.
Was that one of the issues that got brought up in the comments?
Yeah, the lack of definitions around that in particular.
Yeah, it's a good analogy to SBA's recent proposed rule about 8A, where lots of people wrote in and asked, what does it mean by material harm? What are you planning on doing on current firms? And so some of these same issues come up with these shorter policies. I noticed there's only 6 pages, so they didn't go into a lot of detail. So they probably have a lot of work to do in having useful definitions come out in the final rule. A lot of M&A action right now in the defense space. People are getting interested, particularly on high-tech contracts. So venture capital firms, private equity firms are looking at small defense firms. How will this rule change affect the disclosures necessary for those investors?
So this is definitely a point of potential tension between what companies have to disclose to the government and what investors are sort of used to providing in terms of level of detail about their ultimate ownership structure. And we've navigated this issue for quite a long time when it comes to classified contractors with a facility clearance because of the nature of this form. And I think there's been some real progress in the investor base that really focuses on this industry. When you have a classified contractor that's the target of either M&A or financing, that this is going to be part of the process. And I think we're able to get some level of comfort with investors on how they're going to provide that information, what level of information might be necessary. But given that this proposed rule would expand the coverage of these disclosure obligations to so many more contractors in the defense industrial base, I think that is going to increase the number of conversations that really need to be had around this particular subject. One of the questions, the very first question on the SF 328, talks about any foreign person or persons, plural, that own 5% or more of the equity of the business that's under consideration. And what, on sort of first glance, sometimes people think, well, if I, as an investor, don't own more than 5% of this business, then I am not sort of disclosable in this context. But This is from the perspective of the contractor, and they have to aggregate their ownership across investors. So even if you have, let's say, a VC fund that has a very low percentage stake in a company, but they have a limited partner base with some foreign investors. Because the company has to add up the total indirect foreign ownership in their business, that total could go over 5%, which means even pulling in a very small percentage from a particular fund could sort of aggregate to be over that threshold. So sometimes investors are surprised that they're being asked for this type of information given their relative ownership stake in a company, for example. We are already seeing companies that are cognizant that this rule is under evaluation, ask investors at the investment stage for covenants about their requirements to provide information, for reverse diligence about how they're structured as a fund, who's the general partner, where are they organized, what does your LP base look like, et cetera. So some of that is already working its way into the financings and the M&A that's going on right now, based on this rule that we know is coming. And so what we typically suggest for contractors and their investors to understand is that our sort of first response to DCSA is often, here's an aggregate. We have this fund with X percentage total of foreign investors, and here are the totals by country. Okay. And oftentimes, if there's not a large FOCI profile, that can be sufficient. But DCSA will sometimes come back and ask for more granular information about either a particular fund or an LP base or country concentration or something of that nature. And so investors do really need to be prepared for the potential of having to provide additional information.
Could that go to identifying information of the limited partners?
Yes, it could potentially. Now, one workaround may be that we can put investors directly in touch with DCSA rather than providing sensitive information to a company. But I think that having these conversations early on in these deal cycles is going to be really important given how expansive we expect this to be.
Is there any opportunity for pre-transaction engagement with DCSA to clear an investment?
Yeah, it's a great question. So we have typically in the classified space, what we do is we do interact with DCSA ahead of time if we expect there to be a meaningful change in terms of the FOCI profile for the company. And oftentimes what we'll do is then we go through that negotiation pre-closing, and the contractor has to agree to mitigation prior to closing to avoid an invalidation or something else on their clearance. Because if a contractor closes a transaction with meaningful FOCI without engaging with DCSA, their clearance can be invalidated. They may not be able to take on new classified work until it's mitigated. So that is something that we do now. So there's precedent for that. If the FOCI profile for the transaction seems very low risk and unlikely to result in any meaningful mitigation, we still encourage informal communications with DCSA and the points of contact there for the contractor. And then a post-closing submission is what we call a change condition package, which really presents the full body of information about the investment or the new owner. And typically that's fine, again, as long as there's not a significant FOCI profile. But there is some judgment in terms of understanding kind of what that profile is, and that reverse diligence exercise can be really important for contractors.
What have you seen in terms of mitigation? How far does DCSA go? And is there some sort of regulatory scheme around that, or is it just at the discretion of the agency?
Yeah, so there are several common mitigation instruments that DCSA uses. And there's a lot of information actually even on their website that talks about, it gives sample policies and a bunch of other resources for contractors. So kind of the spectrum that we work within now is at the very low end of the spectrum, a board resolution that just recognizes that an uncleared parent company can't access classified information. And then kind of the level of onerousness moves up the spectrum to a security control agreement, a special security agreement, and a proxy agreement. And each of those agreements has a series of security measures in them. They require certain elements of board representation by outside directors who are cleared U.S. persons with no prior relationship with either the company or investor. They have a government security committee, which is a subcommittee of the board that really oversees the mitigation implementation. And then a series of ancillary agreements, a technology control plan, a visitation policy. We often see an electronic communications policy for a company, what we call an affiliated operations plan, which is any like co-location of facilities or involvement in the business. So there's kind of this suite of materials that DCSA uses traditionally. We expect, at least now, that DCSA will continue to leverage those same mitigation instruments in this context, but it's possible that they start to come up with some modifications to those or other measures that maybe are more appropriate in certain circumstances. That's not something that we have a lot of detail about yet in terms of how DCSA plans to approach that mitigation exercise.
And if a company gets into a mitigation plan, maybe involving agreements or a committee of the board, is there monitoring after that, or are there periodic reports that go to the government?
Yeah, both. So the facility security officer for the company, the FSO, is really the person who's in charge of the industrial security program for a company. But in a mitigated entity, the government security committee of the board is responsible for oversight, essentially, of the FSO and his or her operations. There are periodic reports that go to DCSA about compliance with the mitigation instrument. DCSA comes in and does audits periodically of contractors. Contractors do self-assessments of their performance. And so there is this ongoing monitoring process that contractors are required to implement as part of being a FOCI mitigated company in the classified world.
Okay, so that can be a serious compliance exercise after the fact.
Yes, for sure. And that lasts as long as there are classified agreements in place. Once, if a contractor winds down its classified operations, then eventually the facility clearance will be administratively terminated. But otherwise, while they're engaged in that activity, they're under sort of this compliance regime, which entails both internal infrastructure and this engagement with DCSA.
But porting that over to the possible finalization of the proposed rule, it could be unclassified work as long as it reaches this $5 million threshold. Yeah. In reading this rule, it jumped out at me that there was a provision about 3 business days. Nothing in the government happens in 3 business days. So tell me, what is the 3 business day timeline? What does it cover, and how do companies meet that deadline?
Sure. So this involves circumstances where a FOCI profile for a company has changed, right? So something has happened, whether it's an ownership change or something else, that the contractor has to report that change to DCSA by way of a revised SF-328. And the same is true of a contractor who is notified by a subcontractor that the subcontractor's profile has changed. So that report needs to go to DCSA. And then the 3 business day requirement is that the company has to provide information about the beneficial owner, right, the changed person, and has to describe what mitigation strategies it's implemented so far to deal with whatever that FOCI vector is. So that's kind of the initial reporting and information that needs to go to DCSA. Following that submission, there's a 10-day requirement in the rule. So once that submission goes in, DCSA will then evaluate and let the contractor know if they do evaluate it to pose some risk. Once that evaluation comes back, the contractor has 10 business days to confirm that it's going to comply with whatever the proposed mitigation strategy is, provide any additional information it now has about the beneficial owner at issue, and again, sort of update its description of the mitigation strategies it's undertaken so far. These are very tight timelines. And again, the mitigation and implementation process can take quite a long time. If you think about the suite of mitigation instruments I described, we're talking about board involvement, a subcommittee of the board, we're talking about the industrial security staff, contracting staff, finance, IT, accounting. I mean, there's a huge swath of a company that needs to be involved in identifying what these measures need to be and put them in place, much less the flow of information about changes in a FOCI profile, right? Sure. Let's say there's an ownership change in the works. is your FSO always going to be aware of that, or someone who has cognizance over the industrial security program, and in this context, essentially the contracting function as a whole? How does that information flow within a company? When do you need to read in the right people in your company to make sure these reporting obligations are tracked and complied with? So that infrastructure, I think, is going to be a big lift for contractors, and particularly small businesses who are, relatively constrained in terms of resources anyway. So that's certainly something that gives me some pause in terms of how companies can really implement this realistically, including kind of the upfront implementation costs, which could potentially be significant.
And you said any vector. Does that mean if you brought on a new customer that's foreign, that you would have to report that under the 3-day rule? Would that apply?
Yeah, so it's changes to the SF328. Now, what's interesting is that the 3-day and the 10-day requirements talk about providing information for beneficial owners that are implicated, but that really only gets to the ownership piece. So it'll be interesting to see if additional information about other aspects of the FOCI profile will ultimately be required, either in a final rule or more in sort of the implementation guidance that we see.
You also mentioned subcontractors. What is the flow down responsibility here for primes, and what do they do if they're not getting the information that they need from subcontractors?
Yeah, it has the potential to be I think tricky, because you do have a flow down requirement. So the rule requires coverage right now for contractors and subcontractors with contracts over $5 million. So subcontractors at any tier are also covered if they meet that threshold. The subcontractor is required to have an eligible status in NIS, which is the DCSA portal that really manages this FOCI information. There are some open questions about how a prime contractor is really going to validate that, because when you as a prime contractor log into your NIS account, you can't go in and check the status of other companies, right? Mm-hmm. So you are relying to some extent on a subcontractor certification. And then there's not a well-defined workflow with DCSA for processing subcontractors. Theoretically, there should be some element of a contractor notifying DCSA to collect the information, do the validation, and then come back to a contractor about what the status is, because they can't independently verify that status themselves. If a subcontractor is either not approved through this process, unwilling to implement mitigation, or just won't give you the information, this rule prohibits that prime from awarding that subcontract. Oh, wow. Which could certainly jeopardize performance. Our prime's going to have 2 and 3 options lined up for every sort of capability that they need. That's, I think, definitely one of the big open questions as well.
So this isn't just the prime contractor base. You're looking all the way down the supply chain as well. So what's the worst thing that can happen here if you get mitigation measures directed at you, you don't do it, or you don't report? Does this lead to termination, suspension of a contract? Does it lead to potential suspension and debarment?
Yeah, so what we would be probably looking at in most circumstances is a contract termination. The contract to be awarded in the first place, the contractor has to go through this process. It's for new awards. And so if they were in that process and didn't either agree to mitigation or provide fulsome information, they wouldn't be eligible for award. So that's kind of at the front end. But the rule covers extensions and modifications of contracts as well. So existing contractors, either now or in the future, would also be subject to these requirements. If a contractor is not following whatever the ultimate requirements are, providing the disclosures, agreeing to mitigation, then they would either be ineligible for an option exercise, ineligible for a modification, or subject to potential contract termination in one way or another. So that's really, I think, from a practical perspective, what we'd see in most circumstances. There is always the specter of False Claims Act liability. So let's say you've submitted this form, but there's false information, and that rises to the level of a False Claims Act case. Then we could be looking at some potential serious civil penalties and damages associated with that. I think contractors, whether they're talking about cybersecurity requirements or small business eligibility or anything else, this is kind of another bucket of potential liability through that FCA mechanism that the government has. And it wouldn't surprise me at all to see some real initiatives out of the government for enforcement in this particular area.
Sure. You've seen cases about CUI handling, disclosures there, small business. This seems like this could be another bomb that's waiting to go off. Wow. The rule says that the government expects annual cases to grow from 2,000, that's the classified contracts, I presume, to now 41,000. What do you think about that number, first of all? And then if you're increasing things 20 times, how is that going to affect the timelines that you were talking about at the beginning?
The numbers themselves are based on some just sort of rough calculations in the proposed rule. They're kind of making some assumptions about the number of offerors per contract, the number of subcontractors per contract award, the number of modifications and option exercises that come up. So it's, I think, a very rough estimate, and it's possible that it could be substantially more than what they've really estimated. I think the conversations that are happening right now on the industry side are very much concerned with how that's going to impact the acquisition cycles. Does DCSA really have the staff to handle that level of an increase? Is the NIST platform itself capable of really scaling up in that way? Do they need to implement some third-party assessors the way that we've seen in other contexts like CMMC? And so I think that sort of resource piece of the equation hasn't really been fully vetted in at least a public way. Obviously, we're not privy to the conversations that are happening internally. Mm-hmm. We understand there has been some effort to start ramping up staff and make sure they're trained, but that could really potentially slow down some of these acquisition cycles. Now, you've got in the rule that 25-day requirement from when a form or package is submitted to when DCSA is supposed to provide the assessment. But after that, there is a period of time where the contracting officer and the contractor negotiate the proposed mitigation. Once you get to contract award, there's this post-award implementation timeline. So, how long it takes to really negotiate the mitigation package is a huge open question. Whether DCSA is going to be able to process realistically in that 25 days, also open question. How long will it take offerors to really prepare these materials in a fulsome way? That can be a huge exercise for a company that's not familiar with these requirements, which most aren't. I mean, they just haven't had occasion to go through them before. And so the 25-day clock is not really starting even until you've provided all the information that you need to. And so I think the implementation piece does have a potential of really slowing down those acquisition cycles. One of the suggestions that we saw in the comments would be interesting to see if DCSA or DoD bites on it, would be rolling this out in a more kind of phased manner where you focus a little bit more on kind of the most sensitive programs, the data that they're really concerned about, and you start getting some of these test cases in. And then you start to try to get your processes down before you start expanding it really all the way down to that $5 million threshold. So that's a possibility that we see them give both industry and DCSA a little bit more of a phased timeline to really get their arms around what's required and to start putting in place a lot of the resources they could need.
And similar again to CMMC, where we had these multiple phases, and now we've stopped on phase 2. Yeah. And just to note that 41,000, that estimate is off of the $5 million threshold. Mm-hmm. Now there's a proposal on the Hill to lower that even more, now down to $500,000. So lower it 10 times to $500,000. Why are politicians looking at the NDA interested in this issue? Why has this become a possible new proposal now in the NDAA?
The focus on trying to better understand the contractors that make up the defense industrial base has been a big policy initiative for quite a long time. I think DoD and congresspeople and lots of others sort of in and around this space recognize that we have relatively limited information about who contractors are, how they're owned, what their supply chains look like. And so this is actually relatively consistent in terms of the trajectory of those policy initiatives. We see CMMC is a great example. We went from having a regime where contractors self-certify their compliance to requiring a third-party audit of those compliance regimes. We have certain small business programs that require you to go through an SBA assessment or a third-party assessment to make sure that you're actually qualified. We see new rules every year about supply chain, about, how do you validate that your software is secure? What information do you need to provide about where your products are coming from? And so I think that if we think about sort of the broader context, this rule actually fits pretty squarely within that trajectory of trying to get their arms around who's really providing goods and services to the government, and particularly the Defense Department. And so I think that there's been an interest in this for a long time, and now they're really just trying to figure out how to implement it in a way that gets us the information that they'd like. Certainly dropping the threshold substantially will even further increase a lot of the concerns we've already talked about, right? The cost of compliance, how DCSA handles the workload. I think another sort of interesting subset of the comments that we saw come in wondered about sort of why we're picking a monetary threshold at all, and whether it would make more sense to try to, again, analyze more sensitive data access, programs that are particular in nature, because you could have a $10 million contract for something that's completely benign and involves no sensitive data whatsoever, or you could have a $200,000 requirement where you're really concerned that this contractor has access to some very sensitive government systems, or is providing a very key component of those systems. And don't we want to understand, their ownership, control, and influence by potential adversaries than, the $5 million commercial contractor? So I think that, thinking about how you actually translate what is a valid and long-standing policy goal into a rule that is workable, both for contractors and the government, is really the kind of push and pull that we're seeing now.
The big tension, you saw this with CMMC, you see it with a lot of the small business regulations, is on one hand, yes, you want that information, or you want to keep the classified information confidential. In this case, if you have CUI, you want to make sure that that doesn't get into the hands of foreign actors. But you also want to encourage companies to participate in defense contracting, and particularly companies that they call the non-traditional contractors that are not already established in the space, particularly commercial contractors, because the government is behind the commercial sector in implementing high technologies. So this rule says that it could affect up to 21,000 small businesses at the prime or sub level. What is compliance going to look like for the smaller of the small businesses, or businesses that are not used to working in the defense space and then now realize, oh, not only do I have these things that I've already heard of, CMMC, small business, but I also have this FOCI responsibility I have to deal with?
Yeah, I think it's going to require a dedicated person or set of staff internally to really monitor this. Now, does that have to be a full-time person? Maybe it depends on the nature of their ownership structure. But, there really needs to be kind of someone who's at the helm of taking responsibility, of understanding what the requirements are, tracking updates over time, complying with these timelines, much like we see in some of the other regulatory regimes. One of the big challenges that I worry about for small businesses is that this has the potential of really front loading a lot of those costs. So before you even have a contract award, you need to go through this disclosure exercise, gather all the information, provide all the documents, go through a negotiation of mitigation, agree to some interim measures, right? And think about implementation. And then you get your contract award, right? You haven't had a single dollar come in until then. And you might not even be the awardee, because it's offerors for a contract that are really going through this process. So that's, I think, one of my big concerns, is that sort of front loading of the obligations for small businesses. Another is that if this does delay acquisition cycles, you may be in a position as a small business where that is existential for your company, right? You're waiting for that contract award to come in so you can literally pay your bills next month. And so that does, I think, have the potential for depressing the involvement of small businesses, commercial companies, non-traditional contractors in this space. When you're talking just about outside of the classified environment, I think lots of those contractors can still find ways to participate in defense contracting without sort of intentionally staying away from classified work, at least at the sort of early stages of their growth. But once this expands to 5 million or 500,000, I think you're really going to see a lot more of that impact. It's also interesting because we've seen some initiatives over the years and even recently, this sort of push towards commercial items, towards non-traditional companies, getting additional innovation, speeding up acquisition cycles, reducing bureaucracy and sort of the compliance obligations. And so this is definitely something that would be, what I don't want to say a reversal necessarily, but be a little bit in conflict with some of those broader initiatives that we've seen for quite a long time.
And very expensive. Could you put a ballpark figure on how much it would cost a small business from the outside to get into this?
Yeah, I think it's really hard to estimate because a lot depends on how significant their FOCI profile is. You may have a small business where you have one owner or two owners, they're both U.S. citizens, they do purely domestic work, and you're going to have no answers, and that's kind of the end of it, right? Now, later stage growth in that same company, you have new investors coming in, hopefully you're vetting those investors, and then you're talking about kind of slowly ramping up the requirements for disclosure here, which I think would track the uptick in compliance costs and requirements with sort of the growth of the company. But if you have a company who already has a couple of investors on their cap table, or has, for some reason, a customer concentration overseas, or a significant number of employees on visa status, that is maybe a disconnect between where the company is growth-wise and what the compliance burden is really going to be for that contractor. And so we see small businesses navigate this in the classified space routinely, and they can do very well with it. But those contractors have really self-selected to be in this space. So we might see a really outsized impact on some of those small and non-traditional contractors.
And in the CMMC pause this week, Department of War said their main reason for doing that was to alleviate the burden on the small business industrial base. They had heard estimates of $50,000 or so or more to get that phase 2 certification. How do you think this rule, if finalized, would affect the industrial base, small businesses in particular? And what's your prediction? Do you think they'll go through it as identified here, particularly after watching the phase 2 pause?
So I think that the phase 2 pause is a really interesting potential corollary to where this rule is now. The concerns you highlighted, right? They're worried about impact on small businesses and non-traditional contractors, cost of compliance, complex timelines, the lack of resources or third-party assessors. And I think you could say all of that about what this rule has the potential really of landing on both contractors and DCSA as the primary regulator. And so I wouldn't be surprised if we see DoD take a step back from this proposal and think a little bit more critically about something that is more detailed in terms of how the implementation rollout is going to go, involves some more definition around commercial items, for example, and how those will be treated. And then also potentially considers more of a phased approach of really focusing on the highest priority systems first, and then kind of slowly rolling out to other contractors. So, maybe lessons taken from the CMMC issues they've seen. I think across the board in the comments, we saw support for the overall policy. I don't think anyone disagrees that it's a worthwhile exercise to make sure we have better insight into and mitigation of potential foreign access and influence in very critical programs for DoD. And so really it comes down to how do we implement that in a way that doesn't grind acquisition to a halt, doesn't keep small and innovative companies out of the defense industrial base, and is also manageable on the government side.
Erin, how do people find you if they want to learn more about the policy or they want your help with going through the process?
Yeah, so you can find me on LinkedIn. I would be happy to talk to anyone who's curious about this rule. Luckily, the defense bar, the contracting attorneys who really live and breathe in this space, we are a relatively small community, and so we talk a lot about how these are impacting our clients and what we expect to see. So it's nice to have kind of that community aspect around any time we have a rollout of something along these lines. So I can't thank you enough for having me today. I really appreciate it and look forward to continuing the conversation.
Erin Estevez, thanks so much for being on the show.
Thanks, Sam. Appreciate it.
Thanks, everybody.